The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined this week by Evan Bernick of IJ's Center for Judicial Engagement, as well as special guest Robert Everett Johnson. This week on the show, life sentences for juvenile offenders, a union activist's neat trick, guards opening prisoners' legal mail, and undergarments and prison tattoos. Rob, kick us off.
All right, well, so our first case is out of the Seventh Circuit, and it's a case involving a fellow who committed 2 murders when he was 16 years old. He is now 37 years old, and he's serving 2 successive 55-year sentences. He won't even be eligible for parole until 2050, when he'll be 70 years old. 70 years old. And the question here is, does this violate the Constitution? And you might be thinking, well, the Supreme Court addressed that question in the case of Miller versus Alabama back in 2012. And what they said there was a mandatory life sentence for a juvenile violates the Constitution. But here you have a case where it's not technically a life sentence. He could get out at the age of 70. And also what the majority says is this doesn't violate the Constitution because it wasn't mandatory. The judge had discretion to depart upwards and downwards. And what the majority says is, well, the judge thought about the fact that he was a juvenile and decided to sentence him to this extraordinary sentence anyway.
Right. So, I mean, this is an important and subtle distinction. The Supreme Court actually hasn't held that it violates the Eighth Amendment per se to sentence a juvenile to an effective life sentence. What it has said is that a mandatory sentencing scheme that prevents a judge from taking into consideration his youth as a mitigating factor is unconstitutional. The majority in this opinion basically says that given the fact that the statute at issue provides a range, given the fact that the trial judge at least nominally considered or didn't authoritatively foreclose and ignore the juvenile's age, the fact that this guy is being sentenced to what is effectively a life sentence doesn't per se violate the Constitution. But you do have a dissent by Judge Posner who takes the opposing view.
Yeah, Judge Posner has a fantastic dissent, which starts out by making the point, this is an incredible statistic. He says he looks at a study from the ACLU that finds that the average life expectancy for an African-American prisoner serving a life sentence is 56 years. And so he says this guy is basically serving a life sentence. If he's not even eligible for parole until he's 70, the odds are very good that he'll be dead before that comes along. And what Posner says is that the judge, while he considered this, he considered the age of the offender.
It's not even evident that he considered it. I mean,
right,
there's
it's
one
basically a
sentence
line.
worth of an assertion. Yeah, this guy is 16 or 17 years old. I acknowledge that, but all of these aggravating factors, and that was the end of the judge's analysis.
Yeah, exactly, and that's just not enough. And he also points out that 19 states now prohibit any life sentences for juvenile offenders, which is interesting and something I think that we could see further movement on this issue in the Supreme Court in years ahead.
So does Posner say that this sentence is unconstitutional, or does he ask for, what's the next step for Posner?
The next step is this, for Posner, he's in dissent, so what Posner thinks is actually not relevant to the disposition of this case. But he would have sent it back to the trial judge to give a thorough consideration of the mitigating fact of this guy's youth instead of just stating summarily that, yes, he's young, but he did all of these terrible things, and therefore it's okay to sentence him for an effective life sentence. The really interesting thing that Posner does, from my perspective, is that he grapples with really the underlying premise of the Supreme Court's holding in Miller. It's not simply the fact that an individual is sentenced for this length of time, but it was the mandatory sentencing scheme and the lack of discretion that the Supreme Court reacted to in Miller. And what Posner is pointing out is that to the extent that the Supreme Court held in Miller that you need to have some discretion, the judges need to have some discretion, they actually need to exercise it. They actually need to engage in this particular context, given the fact that the fact of somebody's youth, their lack of moral development and maturity is relevant to determining the severity of how they should be punished. And the trial judge in this case didn't do that.
I think one thing just to be clear about that's important here, too, is nobody is saying that this offender has to be released. The argument is, should he be eligible for parole? Should he be able to go before a parole board and say, I've rehabilitated myself, I'm no longer a danger? And should the parole board be able to consider that? Because the way it stands right now is no matter how rehabilitated he is, no matter what he's done in the 20 years that have gone by since this event, which Posner points out we don't know exactly what happened. It's not in the record, but it sounds like it was basically a street fight between a group of juveniles. He can't present any of that to the parole board. And that's really the question, is just should he be allowed to make that case?
Okay, let's move then to the D.C. Circuit. Evan?
Yeah, so this case involves a restaurant called Scomos of Sausalito. It's a seafood restaurant in California, and for the last 13 years it has recognized a union called Unite Here, which seems to have done, well, very little for the last 13 years except collect dues. One of the employees, frustrated about the fact that the union seems to have been doing nothing, decides to go on the internet, look up the steps one would take to decertify the union, figures out that she needs to get a majority of employees to sign on to a decertification in order to do so, convinces 28 of her fellow employees to sign on to this petition, presents it to her employer, also files a decertification petition with the NLRB, and then the employer decertifies the union. And this turns out to be a problem because in the time that it took for the employer to go about decertifying the union's rep had sprang into action, convinced several employees to withdraw their signatures, and now you have a problem under the National Labor Relations Act, which says basically an employer decertifies the union at its own peril. The ALJ concluded that not only had they violated the National Labor Relations Act, the employer violated the National Labor Relations Act, but imposed a collective bargaining order on the restaurant such that you actually now can't decertify this union for an extended period of time. And the question is whether that judgment, which was later upheld by the NLRB, can stand.
Real quick, what's the NLRB?
So the NLRB is the National Labor Relations Board. It's basically a communistic entity established by the federal government in the 1930s-ish.
And the interesting thing about the NLRB, and this turns out to be relevant to this case, is that unlike a lot of agencies, it operates almost exclusively in terms of the rules it sets through adjudication. So there's reliance on the rules that are set forth in proceedings that the NLRB is bringing against employers, which produces rules that are and rulings that are very, very favorable to employees and to workers. So the NLRB kind of has a notorious pro-union bias, which may or may not have manifested itself in the opinion that the D.C. Circuit decides to vacate on the grounds that it's basically regurgitates analysis in an opinion that's predicated on facts that are entirely different from this case. And the union is really the actor who acted in bad faith in this context.
One of the sort of amazing things about this is the NLRB is saying even if it turns out at the end of the day that a majority of the workers in this restaurant don't want to have the union, and there's sort of a question about that because, as Evan said, they were able to get several of the employers to change their minds, but maybe they're going to change their minds back. But what the NLRB is saying, it doesn't matter. Even if at the end of the day a majority wants to get rid of the union, they're going to be forced to keep the union, and they're going to be forced to keep it for years. And actually, that's the result of the NLRB's decision because 3 years have gone by since all of these events, and the union is still in place at the time of this decision, notwithstanding the wishes of the workers, which it really puts to the lie this whole idea of a union as a sort of voluntary association of the workers. Here we're going to impose a union even if the workers don't want it in the first place.
But fortunately, you have an engaged D.C. Circuit because they look at the underlying ALJ's opinion. They focus on the fact that the analysis that the ALJ was drawing upon was based on a case in which the employer had acted in bad faith, withdrawn information from the union, and then was punished with a collective bargaining order by way of deterring future misconduct. D.C. Circuit points out in this case that the employer acted entirely in good faith. It had a petition that was signed by a majority of the employees. The union rep, despite knowing that this petition had been filed, knowing that a majority of the employees had signed on to this, didn't bother to tell the employer that it was going about and trying to persuade other employees to revoke their signatures, and then tried to take advantage of that after the fact and, but for the D.C. Circuit, would have succeeded to entrench its status despite not having doing anything for 13 years. So you have an engaged D.C. Circuit opinion that overturns a terrible ruling below with respect to the remedy. They still violated the underlying act because
The restaurant did.
Yeah, because this is pro-NLRB case law because it's forged by the NLRB. But the bargaining order is vacated, and the NLRB is going to have to come up with something less draconian because the employer in this case acted with good faith. This is a draconian remedy.
You get a fun, this is one of those fun things that we're starting to see increasingly often, where you have the judge who writes the majority opinion also writes a concurrence in their own majority opinion. And the judge here says, not only is the remedy wrong, but in the concurrence, she says we should also reconsider the underlying merits rule as well.
Okay, well then let's move on to the next case, which comes out of the Ninth Circuit and involves prisoners' legal mail. Rob.
Yeah, so here we have a case. It's actually two cases from the same panel involving prisoners who allege that the prison was reading their legal mail. And in both cases, the prisoner points to a couple of incidences where they got pieces of mail, legal mail. It says on the envelope, this is mail from an attorney, and they'd been opened. And the way it's supposed to work is that prisoners are supposed to actually open your legal mail in front of you if you're a prisoner, so that you can see that they're not reading it. Because obviously the prison has an interest in making sure that nobody's mailing, razor blades into the prison or other contraband. But at the same time, you can't have the prison reading the legal mail of the prisoners, or otherwise how are the prisoners supposed to have a relationship with their attorneys? And so the question is, are those few incidences where they get mail that's already been opened enough to establish a violation of the Constitution? Or do you have to show a sort of longer pattern of behavior in order to establish a violation? Yeah, and what the panel says is, look, a couple incidences, it's enough, even one incident. If it's an instance where the prison is reading your mail and your legal mail, that's enough.
I mean, this is something that we have encountered on Short Circuit again and again, and really it's charted out in a concurring opinion in both of these cases. For decades now, the Supreme Court, in treating of statutory and constitutional claims brought under Section 1983, which is the federal statute that allows you to sue for statutory and constitutional violations, you have to show something resembling an intentional act or a pattern or practice. You have to do something that's really evil and deliberate in order to even get in the courthouse door in the first place. And what the Ninth Circuit does in this case is point out, look, to the extent that somebody's rights have been violated, to the extent that they have had a burden on the exercise of their freedom of speech or their ability to communicate with their attorney, yes, they can get on the courthouse door. They don't need to show a consistent pattern of practice. Now, as it happens, the people in this case did allege that this had happened on a number of occasions, and one of them seems to have indicated, I think, that there was a policy in place. But even irrespective of that, if you have a constitutional injury, you should be able to get in the courthouse door, and the Ninth Circuit in this case affirmed that.
Funny concurring opinion here as well from Judge Bybee, and his take on all of this is that you should never, in any case, be able to establish a violation of the Constitution based on mere negligence. And he says, in this case, it doesn't matter because this wasn't just mere negligence. But he would establish a per se rule that negligence can never violate the Constitution.
And he's citing reams of precedent to the effect that the Supreme Court has taken that view in a number of different contexts. The thing is that there's absolutely nothing in Section 1983 which warrants that. Section 1983, on its face, admits of no immunities, no excuses for your good faith or your lack of maliciousness. And at common law, officers, even of the Crown, acted at their own peril with respect to injuries that they have inflicted on individuals. If your rights were violated, you had a remedy, and it didn't matter that the person who inflicted it was acting in good faith.
Just to play devil's advocate for a second, doesn't the prison have an interest in making sure that the mail, I know the prison wants to make sure razor blades aren't coming in, but what if it's criminal A is writing a letter to criminal B who's in prison and it's just words that they're exchanging, but it's continuing their conspiracy? How does the prison deal with that?
Well, I mean, so here we're only talking about legal mail. So if you have two prisoners who neither of whom is representing the other as a lawyer, then they can read that mail all the time.
Sure, but you just get a mail. You just stamp your envelope and said legal mail.
Oh, well, I mean, if it's not coming from your lawyer, I think they...
Right, but if you could commandeer your lawyers...
Oh, well, and
stationary.
that is a problem. You do have like mob lawyers, for instance, who
Right.
might be serving as a conduit for the mob to talk to a mob boss in prison. But at the end of the day, look, even mobsters are entitled to their lawyer and they're entitled to that confidential
Moreover, if they're
relationship.
actually plotting a conspiracy or they're communicating threats or they're doing things that are legitimately outside of the scope of the First Amendment, we're not even in this territory to begin with. I mean, you don't have a right to engage in a conspiracy to commit violence against other people. So the fact that the communication takes place through speech doesn't mean it would fall within the scope of the First Amendment. There's no claim here that what these people are exchanging is somehow unprotected by the First Amendment or it's a ruse. And
But what John is saying is that how would the prison know if they don't read it? I mean, so you could imagine the mob lawyer is writing to the mob boss and passing on information about the criminal conspiracy. And if you don't read it, you don't know that that's the case.
Well, in that case, and this is a point that the court makes, it's not as if the prison can't win out ultimately by saying, yay, our policy is justified, notwithstanding the fact that you have a First Amendment interest. But you need to offer that justification. You need to take it seriously.
Well, I don't know. I actually think even if, I mean, if you somehow knew that the mob lawyer was doing that, you could probably read the mail. You have an exception to the attorney-client privilege, but if you don't know it, if you can't prove it, that's just a thing that lawyers can do, and I don't think there's a remedy for it.
Yeah, I would say that in that case, if you could demonstrate that what was being communicated between these individuals was something that neither of them had the right to do in the first place, that is something that could be legitimately legitimate grounds for the prison reading the mail. Apparently, we disagree on that. We occasionally have disagreements on short circuits.
Well, with that note, let's move to the final case, which comes out of the Seventh Circuit and also involves prisons. Evan.
Yeah, I don't think there's going to be much disagreement about this case. This involves a series of claims brought by pretrial detainees at the Rock Island Jail in Illinois. What we're going to focus on here is particularly claims that arise from the jail's policy of requiring female detainees to either wear white underwear or no underwear while they're in prison. That means if they're wearing colored underwear, they have to take it off as soon as they get to prison. They need to take it off in front of prison guards. This is obviously a humiliating experience, and the question is, why? Because prisons can't just unilaterally subject people to humiliating treatment. What is the justification for this policy? And that's what really comes into play during this case, because the sheriff who has argued on behalf of this policy has simply said, I understand, I don't believe, but I was told that if inmates are allowed to wear colored underwear, they could potentially synthesize ink that could be used to create tattoos, and this would somehow be a problem that the jail needs to take cognizance of. The only problem is that there's absolutely no evidence to substantiate that whatsoever.
Yeah, I mean, my only comment on this case is it'd be nice if courts exercised the same degree of scrutiny in areas that are more significant than people's underwear.
Yeah, it should be an open and shut case, but or it seems like it should be common sense. But the trial court actually took the sheriff's word and said, "Look, we can find several other cases in which there are policies kind of like this, as it happens, and the Seventh Circuit makes their way through these cases. There aren't. You have some unsupported allegations about particular prisons. Some of them may have had white underwear policies, but there's not a large pattern in practice that suggests that this is a need that prisons have to address. And even if there were, you would still need to demonstrate with credible evidence that this is a problem that needs to be resolved. Apparently, this policy wasn't particularly well enforced to begin with, and it's remarkable to me that it even got to this stage. But such is the deference that judges are prepared to give prisons, apparently, that even at the trial level stage, even without any evidence other than the sheriff saying, "Hey, somebody told me that this would be a problem," they were told that they couldn't bring their claim forward. But the Seventh Circuit sent it back and said, basically, you need more than that.
I mean, just on the flip side here, though, I mean, there's case after case after case saying that when you're booked into one of these detention centers, you can be strip searched, and not like just take your clothes off, but like cavity strip searched. Like bend over and spread and, bend over the mirror so we can look into your wherever. I mean, this is like very invasive stuff that is totally constitutional according to the courts. And yet, apparently, it violates the Constitution to say what color underwear people can wear. So I'm not saying the decision's wrong, but, come on.
My response to that would be the greater includes the lesser argument. Yes, well, the fact is that when you get detained in a prison, you are subjected to restrictions on your liberty and asked to do things that government actors couldn't normally require you to do. But you still need to draw limiting principles and distinguish between things that are arbitrary, that serve legitimate penological purposes, and things that do not. So even if, under certain circumstances, you could have a rectal cavity search because you have reasons to believe that somebody's hiding drugs.
No, you can. Prisons can have a blanket policy of giving a rectal search to every single person who enters the prison.
And if they have evidence demonstrating that that's a problem and that this is a means that's necessary to address that problem, that's fine. But if you can't come up with a reason why detainees have to wear white underwear as opposed to colored underwear, the fact that you can do more intrusive things to address something that you do have evidence to believe is a problem doesn't mean that you can.
I'm not saying I disagree. I just think there's a certain oddness that this is the case where the courts decide to be.
You got to start somewhere.
Okay, that concludes the show. Thanks for listening, and we'll be back soon. Until next time, this is John Ross from the Institute for Justice, inspiring you to get engaged.